Welcome to the Deep Dive. We're here to help you make sense of complex topics quickly.
hmm
And today we're digging into something really central for anyone looking at law and governance, maybe especially if you're prepping for UPSC exams.
That's right.
It's this relationship, right, between how we actually define crimes and then how the legal system acts on those definitions.
Exactly. It's not just about knowing what the law says. It's about understanding the machinery behind it, the engine room, you could say.
Okay, so the core question we're tackling is, why is the process of enforcing criminal law just as vital as the laws themselves?
Precisely. We often hear about substantive law. What's a crime? What's the punishment? But today, we're focusing on procedural law, the how.
The how. And our source for this deep dive.
We're drawing heavily on a really insightful piece from the Hindu. It gives a great perspective on this, especially with some recent legal developments.
Got it. So the mission is to shine a light on this procedural side, its role in fairness and justice.
Absolutely.
Right.
It's often in the background, but it's critical.
Okay, let's start there then. Substantive versus procedural law. I mean, instinctively you'd think substantive law defining the crimes, the punishment, that's the main thing, right? The moral compass.
Well, that's a good way to put it. The compass. Substantive law definitely sets those boundaries, tells us what's wrong, what happens if you cross the line.
But
But procedural law, that's the operating system. It's the framework that actually makes that compass work in the real world. It lays out all the rules.
rules for investigations, evidence, rights of the accused, the trial itself, all of that.
All of that. So if substantive law says, I don't know, theft gets you X years, procedural law says how police investigate, how they gather proofs, what rights you have if you're questioned, the steps in court,
Okay.
how you get to that verdict.
And this is where maybe for the UPSC folks listening, it gets deeper than just definitions.
Definitely. It's not just a technicality. The Hindu piece called it the beating heart of action in criminal justice. I thought that was quite evocative.
The beating heart.
Yeah. Because it's the mechanism that controls how the state uses its power. It's pretty significant power to take away someone's liberty. It ensures that power stays within legitimate bounds.
Right. And this brings us to that Supreme Court case you mentioned, Imran Pratapgarhi versus State of Gujarat. How does that case, really highlight this?
Yes. But Pratapgarhi is a perfect example and quite recent. The key thing there is the Supreme Court quashed an FIR.
Okay.
But not because they decided the alleged act wasn't an offense under substantive law. No.
So why then?
Because the police hadn't followed a specific mandatory procedural step. They were supposed to conduct a preliminary inquiry before registering the FIR, and they didn't.
Wow. So the process itself was flawed.
Exactly. And the ruling really underscored this principle. Fair criminalization isn't just about having a justifiable law defining the crime. It's just as much about the integrity of the process used to enforce it.
So the how isn't secondary to the what, they're intertwined.
Deeply intertwined. Principled criminalization needs both. Just substance and just procedure.
Okay. Now, the Hindu article also delves into the why behind the state having this power to criminalize things in the first place, the theory behind it.
Right. It touches on legal philosophy. Victor Tadros, for instance, argues it's not just a power, but actually an ethical duty of the state.
A duty.
Yes, a duty not just to label something a crime, but to follow through, prosecute, condemn through conviction, and punish. It's the state's way of responding formally to wrongdoing.
But it's not the only way society deals with wrongs, obviously.
Oh, absolutely not. We have social norms, family, community pressure, civil lawsuits, lots of other mechanisms. Criminal law is or should be a specific tool for specific kinds of harm.
And there are principles guiding when to use it.
Yes, Tatiana Hernal suggests three key ones: protecting collective interests, guarding against violence, and upholding people's right to basically be left alone non-intervention. The idea is to reserve criminal law for serious stuff.
And the article notes these ideas are reflected in India's new Bharatiya Nyaya Sanhita, the BNS.
Theoretically, the BNS aims to embody these principles in its definitions of offenses.
But here's the potential disconnect, right, between the theory and the substantive law, like the BNS, and what actually happens on the ground.
Precisely. That's where procedural law becomes so vital, because the actual process, how a crime gets detected, reported, how an FIR gets registered, the investigation, arrests, prosecution, sentencing, that journey can look very different from the neat principles in the books.
How so?
Well, things like systemic biases can creep in. Discretionary decisions at different stages, maybe resource issues. They can lead to certain behaviors or even certain groups being targeted more, sometimes unintentionally. Over-criminalization, essentially.
Which makes strong procedural rules and oversight absolutely necessary, kind of like guardrails for the whole system.
Exactly. Guardrails is a good word. They keep the process on track and ensure accountability.
And a huge part of that initial process involves the police, doesn't it?
Oh, fundamentally, they are the gatekeepers, the frontline agents of criminalization. Their decisions whether to even register an FIR, how seriously to investigate, whether to arrest someone, have massive immediate consequences.
So the procedures need to really guide and constrain that police discretion to prevent misuse and ensure things are fair from the very beginning.
That's the goal. Which leads us to a specific procedural innovation highlighted in the Hindu piece, section 173, of the new Bharatiya Nagarika Suraksha Sanhita, the BNSS. This is quite relevant, especially thinking about fundamental rights, a key area for UPSC.
Okay, section 173 of the BNSS, what does it do?
My understanding is it mandates a preliminary inquiry by the police before they register an FIR, but specifically for cognizable offenses where the punishment is between 3 and 7 years. Not for everything, but for that middle band.
And cognizable means the police can arrest without a warrant, right?
Correct.
So that makes this preliminary check even more important.
Absolutely.
Yeah.
Because the power to arrest without a warrant is significant. This preliminary inquiry under 173(3) acts as a filter. It gives police a chance to check if a complaint holds water, if there's actually enough substance to start a full criminal case before taking the big step of an FIR.
And you mentioned fundamental rights.
Yes, particularly relevant where allegations might touch on things like freedom of speech. You don't want FIRs registered hastily in ways that could shut down legitimate expression. This inquiry is meant to be a safeguard against that, too.
Which loops right back to Imran Pratapgarhi. That's exactly what happened there, wasn't it? The FIR was thrown out because they skipped this step.
Precisely. The Supreme Court was very clear. They said this kind of preliminary inquiry requirement, which is now formalized in Section 117(3), is there to stop the criminal justice system being misused.
Misused how?
To, stifle genuine speech, maybe for political reasons, things like that. By forcing this initial check, the law tries to reduce the chilling effect that a quick FIR, especially in these cognizable cases, can have on basic rights and public debate. Analyzing that balance is crucial for understanding our constitutional setup.
Okay, so pulling it all together. The state's power to call something a crime and punish it, its legitimacy doesn't just rest on having good laws written down.
Not at all.
It's equally, maybe even more critical, how those laws are actually put into practice. The procedural part. That seems vital for understanding how governance works day to day and how rights are protected or not.
That's the absolute core of it. Principled criminalization needs both sides of the coin. You need substance grounded in constitutional values, clear laws, but you also need procedural integrity, restraint, fairness, following the rules and how you enforce them.
And the Pratapgarhi judgment.
It serves as a really powerful reminder that procedure isn't just some boring technicality. It's central to justice. It's about balancing state authority with accountability in a democracy. Understanding this dynamic is, I think, essential for anyone seriously studying our legal and political systems, like UPSC aspirants.
So the big takeaway for you listening, especially if you're studying for the exams, don't underestimate procedural law. It's not just footnotes. It's the framework that dictates how justice is actually experienced, how rights are practically protected.
Right. It's the unseen machinery, but it shapes everything.
Absolutely critical for understanding governance in India.
And maybe a final thought to leave you with.
Yeah.
Think about how digging into these procedural details gives you a much clearer, more practical view of how governance really operates and how individual freedoms are actually safeguarded or challenged in a democracy.
It's not just about the what on paper.
No, it's the how on the ground that truly matters for a full picture.
Well said. If you found this useful and want more deep dives, especially on topics relevant to current affairs and the UPSC syllabus, please do like, subscribe, and drop a comment. Let us know your questions or ideas for other topics.
And just to reiterate, our discussion today on this crucial balance between substantive and procedural law drew heavily from analysis and legal commentary featured in the Hindu.